Good morning. This morning we are hearing the appeal of Michael Misick and others, and I'm going to turn immediately to Mr. Edward Fitzgerald QC, who with others represents the appellants in the appeal. Mr. Fitzgerald.
Yes, my lady, I appear in this matter, as the court knows, with Daniela Wadoop of the English Bar and with Ariel Misick, Queen's Counsel, and Selvin Hawkins of the Bar of Turks and Caicos. My known friend, Mr. Andrew Mitchell, appears with Quinn Hawkins and Catherine Duncan, and with Letitia Williams of the Bar of Turks and Caicos. My lady, I hope that the court received our reply and also a communication yesterday indicating that we will not be pursuing ground 2, the in personam point. And so we are pursuing ground 1, that the regulation 4.6 is null and void because it's unconstitutional and unlawful, and we are pursuing the equality of arms point. My lady, just by way of...
Yes, I was going to wonder whether we could just do a little bit of housekeeping before you get into the swing of your submissions. First question is to find out whether there's been any development of the situation in the Turks and Caicos. I understood that there was a relaxation in the latest practice direction, but we were wondering whether you can update us on the position. For example, whether there are any regulations that prevent people travelling in and out of the islands.
Not so far as I'm aware. I think that the update at the beginning of the case is the position at present, which is at paragraph 5 of the case at page 412. But no doubt I'll be corrected by my learned friend if I've got that wrong.
But I thought it was probably useful to ask these questions at the outset because they may get input from both sides.
Yes.
Second factual question, has the judge made any decision yet as to the method by which he will conduct the trial?
No, as I understand it, he's awaiting the outcome of this ruling.
Thank you. And then two matters on your case. In relation to ground 1, is it common ground now that the court has got to sit in the Turks and Caicos Islands? That's how I've understood it from the respondent's case. I can see you're probably looking at the, if we were here physically, you'd be looking at the respondent.
Well, yes, my lady, we say the court has got to sit in the Turks and Caicos. My learned friend says it is sitting in it would be sitting in the Turks and Caicos because the judge would simply be beaming in to that location.
I thought the focus of the argument was therefore upon whether the judge was actually sitting in whether the court was actually sitting in the Turks and Caicos Islands, rather than upon whether it has to or not.
Yes, I think that is right, my lady. What we see is that there are two arguments. One is, what is the meaning of Regulation 4.6? And as the court knows, we say it's absolutely plain that on the face of it, it is purporting to make that place where the judge sits abroad into the courtroom. That's what it does. Now, we say that's plainly ultra vires and that you cannot, by any canon of construction, make it intra vires. That does seem to be a second point, which is in the judgment of Justice of Appeals Stolmeyer, which appears to say, forget about Regulation 4.6. There is a common law power, which he derives from Endine, for a judge to beam in, if I can call it that, to the court.
I'm not wanting to take you into the submissions at the moment. Obviously, you'll have as much time as you need to make those, just to see where the focus of the argument is going to be. And the other factual point was about how you were putting your case with regard to whether it's acceptable for the judge to, in your words, beam in to the hearing from somewhere else on the Turks and Caicos Islands. And I think I've got that now from paragraph 3.4 of your reply.
Yes, we've tried to set out the nature of our objection. We say he cannot. That's to say, what he can do is to nominate some place other than the courtroom, such as a hotel or a church, as has happened in England, as the courtroom.
Okay.
But what he can't do is to say, I'm sitting in my bedroom and that's become the courtroom.
Okay. Thank you very much indeed for those preliminary matters. Now, I'm not going to interrupt again, and please do make your submissions.
My lady, I'm very obliged. So our challenge as the court has for us is it's a narrow but an important one, and it concerns the constitutionality of the subsidiary legislation, that is to say Regulation 4.6 of the Emergency Powers Regulation, which you have at tab 11 of the bundle, and it's at page 671 onwards, and the key passages are at page 675. My lady, my lords, you have that there. The courtroom shall include, it says at page 675, any place, whether in or outside of the islands, the judge or magistrate elects to sit to conduct the business of the court, provided always that the video and audio link facility at the said location must be accessible remotely to the court recorder, interpreter in the appropriate cases, parties, counsel, and witnesses. And we say that the courtroom becomes the place where the judge elects to sit if this is intra vares, and that is impermissible. My lady, what we say is that the regulation, according to the respondent, authorizes a Supreme Court judge of the Turks and Caicos Islands to conduct the second half of a criminal trial in the Turks and Caicos whilst he is physically located in Jamaica and therefore outside the territory and jurisdiction of the islands. We recognize that Regulation 4.6 on its words expressly purports to make the courtroom, I quote, any place, whether in or outside of the islands, the judge or magistrate elects to sit to conduct the business of the court. And one can see that because if we go on to the proviso, it says provided always that the video and audio link facility at the said location. Well, what's the said location? It's the place in or outside of the islands where the judge elects to sit, and it must be accessible. So that's what it means. And we say you cannot, by any doctrine of interpretation, make that mean that this is authorization for a judge to beam in. It just doesn't, the language just does not bear that interpretation. We say that it expressly purports to make the place in Jamaica where the judge elects to sit, if he elects to sit in this case, into the courtroom for a TCI trial. And we say that such a provision is unconstitutional and unlawful. Firstly, because it violates the fundamental principle that a judge presiding over a criminal trial should be within the territorial limits of the Turks and Caicos. So that's the principle which is, my ladies indicated that they agree that the courtroom should be, they don't agree that the judge should be. But we say it's a fundamental principle that the judge conducting the trial should be within the territorial limits of the Turks and Caicos Islands. And secondly, it violates the further principle that the defendant should be afforded the right to be present in the same room as the judge as he hears the evidence. My lady, you have indicated already that you've seen from the nature of our objection in the reply 3.4 to 3.6. So that's what we say, that the defendants have a right to be present in the court with the judge when he hears the evidence. The judge should be, if he puts himself in Jamaica, he'd be outside their reach. The facts of the case, then, I can just very briefly summarize. SFI, And the facts of the case are, firstly, this is a long-running trial which was opened by the prosecution as long ago as 2016. That should be, see the chronology at 405. It's the second point we make is it's a judge-only trial without a jury. The judge, Mr. Justice Harrison, is the trier of facts. He is based in Jamaica, and he has been travelling to the TCI to conduct the hearing of the parties and counsel appearing in person before him. And we've got that in the SFI, paragraph 3, in the electronic bundle at page 396. And then staying with the SFI, most of the witnesses have given their evidence in person. Certainly the most important witnesses have given their evidence in person. For example, the Governor and the Attorney General. It's true, and the former Attorney General. And it's true that a substantial number of the witnesses have given their evidence remotely. That's in paragraph 4 of the SFI. But all of them obviously have given their evidence whilst the defendants were in the physical presence of the judge hearing the same evidence as them. The fourth point is that the prosecution case is now closed. That's at paragraph 7 of the SFI, page 396. The second defendant was halfway through his evidence, which was given in like manner, that's to say, in the presence of the judge and in the presence of the defendants. And that's paragraph 7. Then, of course, came the COVID crisis, and then the World Health Organization declaring a global pandemic on the 11th of March. And then on the 20th of March, the governor issued a proclamation of emergency. That is in paragraph 8 of the SFI, and the proclamation itself is at tab 10 of volume 1 of the authority.
I think you've got a question.
I'm so sorry, forgive me, sorry.
Just to clarify, had any other defendants given evidence before the adjournment?
No, my lord.
Just a second.
So the first defendant didn't give evidence, and I think called 2 witnesses or read 2 witnesses. He read 2 witnesses. The second defendant was halfway through his evidence in the sense that he'd given his evidence in chief, and the cross-examination had commenced but not completed, my lord. On the 20th of March, 2020, the governor issued the proclamation of emergency, and unless the court wishes me to take you to the proclamation, it's at tab 10 of volume 1, page 669, but I don't think anything turns on the wording of the proclamation. And the case was then adjourned on the 7th of April by Mr. Justice Harrison. That's in the SFI at paragraph 11. And then Regulation 4.6 came into force on the 20th of April with its express provision for a judge located outside of the islands to elect to sit there and thereby make the place he elected to sit the courtroom. And that you've seen, I took you to it briefly, but the court can see that Regulation 4 and the words 4.6, the courtroom shall include any place, whether in or outside of the islands, the judge or magistrate elects to sit to conduct the business of the court, provided always that the video and audio link facility at the said location. What is the said location? It's the place where the judge or magistrate elects to sit, and it must be accessible. Now, that's what the words mean. The fact that they say, well, it shouldn't mean that because it makes a nonsense of a practice direction issued 3 days later, it is neither here nor there. That's what the words mean. And the words are plainly ultra vires, as Justice Lobban Jackson found at first instance, and as indeed Justice of Appeals Stolmeyer recognized when he looked at the plain words of the statute. So we say it's plainly ultra vires. You cannot derive anything from 4.6. And really what my learned friend is saying is, well, because it is nonsense if you interpret it literally, therefore you have to read in a whole load things about beaming in which aren't there. And we say that violates every canon of construction to start reading in words to try to redeem from unconstitutionality those provisions. Regulation.
Mr. Gerald, I think you've got another question.
I'm so sorry, forgive me. Sorry, my Lord Briggs.
Yes, I think a few moments ago you said there was also a fundamental principle that the defendant was entitled throughout the proceedings to be in the physical presence of the judge. Do you therefore say that Regulation 4.5 is ultra vires, or that it has to be read down so as not to interfere with that principle?
Yes, my Lord, the latter, because it's not quite clear what the rules are going to provide. I mean, remotely could mean that the witnesses attend remotely. That anticipates a practice direction which was then issued, and you have at tab 12, but the practice direction was made 3 days later and cannot be a guide to the meaning of the regulation. You can't start interpreting the regulation made on the 20th of April by reference to a practice direction which was issued on the 23rd of April. And you have that practice direction at tab 12. And you can see that at the end of it, the date is the 23rd of April. That's at page 691. And we say, actually, that the practice direction, which consumed a great deal of time in the Court of Appeal, is irrelevant. You can't interpret the regulation by reference to something which wasn't in existence at the time the regulation was passed. So you have the practice direction if you wish to insert that as a sort of on the 23rd of April, but then on the same day, the 23rd of April, the prosecution, in reliance on Regulation 4.6, applied for the trial to resume with provision for the learned judge to remain in Jamaica should he so wish. Can I just show the court that? Because it is significant, we say, in the record at page 49, one has the application. Starts, and sorry, that the application starts at page 46, but at page 49 it recites paragraph 4.6 at the bottom of page 49 of the e-bundle. The courtroom shall include, and then at paragraph 26 on page 166, paragraph 26, should the learned judge remain in Jamaica, it is suggested that 2 screens be provided and set up so as to replicate current physical setup in court. So it's anticipating the possibility of the judge remaining in Jamaica and therefore definitely relying on Regulation 4.6. My lady and my lords, that no ruling was made as to the appellants, no ruling was made because the appellants then sought to challenge the regulation by way of originating summons, and they alleged that Regulation 4.6 was unconstitutional. That was on the grounds, inter alia, that it violated the right to the protection of the law and was ultra vires the Constitution. And that was because it purported to confer powers on the Supreme Court to conduct proceedings outside of its territorial boundaries. That's in the electronic bundle at page 8 of the record, and the court has that, the application, and one can see the declaration sought at page 8, paragraph 3, a declaration that Regulation 4.6 is ultra vires the governor's powers. The ordinance and the order in its powers, it purports to confer power on the Supreme Court to conduct proceedings outside of its territorial boundaries. My lady, I think I omitted to show the court the primary legislation which this is purportedly in pursuance of. Perhaps if you would forgive me, can I just show you that before I go on with the narrative? The primary legislation in purported pursuance of which Regulation 4.6 was introduced can be found in, firstly, the Emergency Powers Ordinance, which is in Volume 1 of the authorities at electronic bundle page 590, and that's tab 4. So that's the emergency. Yes, 590. Yes, you'll see the emergency powers provisions, Emergency Powers Ordinance, 1962, and it says at 4.1, page 590, when a proclamation of emergency has been made, and so long as the proclamation is in force, it shall be lawful for the governor to make such regulations as appear to him to be necessary. And then one sees that subsection 3, all regulations made under this section shall be laid as soon as may be after the making before the House of Assembly. So it's subject to a negative resolution, and there's no dispute it was laid before the House of Assembly. And then so long as regulations made under this section remain in force, anything inconsistent therewith contained in any law, regulation, order or rule shall be of no effect. But of course they would have to be, we say, in conformity with the Constitution itself. And then if we go on to the...
Mr. Gerald, sorry for interrupting you.
No, man.
But why, it's just a matter of interest, why do they have both an ordinance and also an order in council, both of which confer power on the governor to declare a state of emergency, and both of which confer authority to make regulations? Why have we got those two sitting side by side?
Okay, the first, the one we're just looking at, it is Turks and Caicos specific, as I understand it.
Yes.
The second one applies to all the overseas territories. So the Cayman Islands and other overseas territories also. But my lord, if the question is why the overlap, I'm afraid I can't give the answer other than that one is focused on the Turks and Caicos and the other is more general. But my lord, we say in any event, neither of them authorize a regulation that says a judge can sit outside the Turks and Caicos Islands. And so, my lady and my lords, can I just take you then to that Emergency Powers Overseas Territories Order, which you have at page 592, the 2017 order, so more recent than the Turks and Caicos order. And you can see that there's a power to confer jurisdiction, page 595, 6(3)L on a court or tribunal. There are conditions set out for making the regulations in paragraph 7, which is at the top of page 596. The conditions referred to in Article 6.1 are that the provision is necessary for the purpose of preventing, controlling or mitigating an aspect or effect of the state of public emergency, and B, that the effect of the provision is proportionate to that aspect or effect of the state of public emergency, and the need for the provision is urgent. And then just, if we go on to 8, it's 8.3, regulations may not amend this order, and B, any other order in council that applies to the territories, including the constitution. So that is important, that you can't amend or purport to amend the constitution and its protection. But we say there's nothing, these wide rule-making powers do not provide authority for a regulation that purports to enable a judge to sit outside the jurisdiction, which would be a fundamental departure from basic common law principles. So that's the primary legislation. And then the challenge that was brought, which I've just referred to, and which the board has seen, was brought under the Constitution. And it may be appropriate just to show the court the Constitution at this stage. And can I just show you, first of all, the Constitution is at page 498 onwards of volume 1, so e-bundle 498, if the board has that, and one can see it's made by an order in council, and one can see that the Constitution has a section, a fundamental rights section, which is common throughout the Caribbean jurisdictions, and the court can see at 1 on page 507 of the electronic bundle, whereas every person in the islands is entitled to the fundamental rights and freedoms of the individual, that is to say the right, etc., to each and all of the following, namely, A, life, liberty, security of the person, and the protection of the law. As we've set out in our reply, the provision for the protection of the law does have substantive content. It's been interpreted in the context of the Jamaican Constitution, where section 13A is in identical terms, to provide a substantive protection, and we set that out at 2.4 of the reply at pages 5 to 6. But just for the protection of the law principle is a fundamental principle, and it enshrines the concept of the rule of law, and that we derive from Neville Lewis and the Attorney General, and we've set out the references. So it does have substantive content, and it enshrines protection for those parts of the common law and existing law that make up the fundamental parts of the rule of law. And we say the principle that a judge can't sit outside the jurisdiction in respect of which they're exercising power, it is such a fundamental principle. And if we go on from 1A, you can see also at section 6, which deals with the person charged with a criminal offence at page 509 of the electronic bundle. If any person is charged with a criminal offence, then unless the charge is withdrawn, the case shall be afforded a fair hearing within a reasonable time by an independent and impartial court established by law. So it must be a court established by law. And we would say that that's a court established by law and acting within the jurisdiction. And then at 6.2, every person who is charged with a criminal offence, D, shall be permitted to defend himself or herself before the court in person. We say that that too is an indication of the content of the protection of the law, and it's also a freestanding right to defend yourself in person. And we say that that connotes primary meaning is in person before the court. And then at 6.9, which was referred to by the judges, at page 510, all proceedings instituted in any court for the determination of the existence or extent of any civil right or obligation or to try any criminal charge shall be held in public. If I can just then take you to section 20, which features in the judgment of Mrs. Justice Loven Jackson at page 518, section 20, nothing contained in or done under the authority of any regulations made under the Emergency Powers Ordinance or any other law, the like effect shall be held to be inconsistent with or in contravention of section 5, section 6, which is the equivalent of Article 6, European Convention, other than subsections 4, 5, and 6, or any provisions of sections 7 to 19 inclusive, to the extent that the regulation in question makes a provision that is reasonably justifiable in the circumstances of any situation arising or existing during that period for the purpose of dealing with that situation. So firstly, there are certain deeply entrenched provisions which it doesn't apply to, and those include 1A, which is such a deeply entrenched provision. Secondly, even if one were only relying on 6.4, it would still not prevail over the regulation would not prevail over the Constitution if it was not reasonably justifiable in the circumstances of any situation arising. And then just finally, because it was the section that was invoked, section 21, the enforcement of fundamental rights, the right of any person to apply to the Supreme Court, and the Supreme Court then has original jurisdiction to hear and determine any application. Unless there's a means of redress under any other law. My lady, I don't think I need take the court to any other provisions of the Constitution, but that's the situation.
Mr. Fitzgerald, just before you leave the Constitution, I was wondering where you get your inalienable right as a defendant to be face to face with the judge. Is it 6.2 sub D that you're relying on at section page 509, the right to defend in person? Some might say that's a right to do so without lawyers, or alternatively, if you want, with lawyers, rather than a right to do it face to face in a situation where there is permission for virtual hearings.
Yes. Well, my lord, that's the first thing we rely on. But the second thing we rely on is the protection of law in the deeply entrenched provisions of 1A. And we say, and I hope to make it good, we say that the notion that you're present in the court with the judge is a fundamental part of the rule of law and the protection of the law. That's what's envisaged by a trial. Co-presence, coram the judge, is what. But my lord, I take your point about in person, but shall be permitted to defend himself in person, or by a legal representative. Yes, I take your lordship's point. The trial should not, and then, but just go on from there, and except with his or her own consent, the trial shall not take place in his or her absence.
Mr. Fitzgerald, there are authorities on defendants being required to be present in court so that they can be seen by members of the jury, and so that they can, on occasions, they apply to leave. And that application is refused. But the answer to that is that they can be seen by a video link, and they can be seen by the judge by video link, and they can see the judge by a video link. So I'm skeptical at present about the concept that they actually have to be physically present in the courtroom. Why is it that it is insufficient for them to be seen over a video link and to see the judge over a video link?
Well, my lord, because firstly it's second best, that medium of witnessing the trial, and that's really the most fundamental point, my lord. That can be dispensed with at their election, of course. I mean, except you can waive that right. But we say that if the defendant says, "I wish to be present," when the witnesses are actually heard by the judge and to see what the judge sees, we say that is a fundamental part of the rule of law. My lord, that may not adequately address your question at the moment, but can I reflect on it further?
Well, I was just thinking of vulnerable witnesses who are secreted in some other part of the building and give their evidence by video, and
yes,
and the world has moved on.
Well, I accept that, my lord, but in that case, you and the judge are still in the same room, experiencing the same experience, as it were. The defendant has the right to be there and to see exactly what the judge sees, in the same way as the judge sees it. In this case, for example, some of the witnesses gave evidence by video, but they gave evidence by video seen by the judge and the defendants at the same time in the same way. So, my lord, I accept that witnesses can give their evidence remotely, and that, if I can put it that way, that ship has sailed. But they are still present before the judge, seeing what the judge sees in the same way as the judge sees it. So, my lord, that's why we say that that's a fundamental principle. My lord, my ladies and my lords, that I should, of course, take you, while I'm on the Constitution, to Part 5, page 541, and because this was relied on also by Her Ladyship Justice Lobbin Jackson. If you look at page 541 of the electronic bundle, Part 5, the Judicature, it says the Constitution of the Supreme Court. There shall be a Supreme Court for the Turks and Caicos Islands, which shall have such jurisdiction and powers as may be conferred on it by this Constitution and any other law. And then, if I can take the court to to section 80 of the Constitution, one sees under the Court of Appeal, 81, there shall be a Court of Appeal for the Turks and Caicos Islands, which shall have such jurisdiction and powers as may be conferred on it by this Constitution and any other law. And then, for the purpose of hearing and determining appeals to the Court of Appeal, the Court of Appeal may sit either in the islands or in such places outside the islands as the President of the Court may from time to time direct. And sit, obviously, there means actually sit, just as we say sit means actually sit in the regulation. So there is express provision in respect of the Court of Appeal that it may sit either in the islands or in such places outside the islands as the President of the Court of Appeal may direct. That may go back to the time when the Court of Appeal sat first in Jamaica and then later in the Bahamas, the Court of Appeal for the Turks and Caicos. But we do attach significance to the fact that there is that express provision in relation to the Court of Appeal, but no such express provision in relation to the Supreme Court, that it may sit outside the islands. And so, and as my lady observed, it does seem to be accepted that the Supreme Court cannot, in fact, sit outside the islands, although we say that's unfortunately what Regulation 4.6 purports to say, may sit in any place inside or outside the islands. Now, my lady, if I can then turn to the judgment of Mrs. Justice Lobbin Jackson.
Mr. Fitzgerald, forgive me. Do we know, in the circumstances where the Court of Appeal sat outside the Turks and Caicos Island to hear appeals, were the defendants taken to wherever the court was sitting?
No, I think that there is provision that they could detain people. So I think they were in some cases, because there's actual specific provisions for them to be detained there. So it may be that certainly there were, but certainly counsel would travel, obviously to the Bahamas or to Jamaica to present their case. Yes. And to present their cases. But my Lord, there's certainly express provision for a power to detain in Jamaica or Bahamas at that time. So it was envisaged that certainly in some cases the defendants were. But
yes, thank you.
My Lord, obviously we do draw a distinction between the Court of Appeal and the primary decision-making trial court. Sorry, my Lord Briggs.
Yes, Mr. Fitzgerald, you said that may sit, where it's where that phrase is used in the Constitution, must mean may actually sit.
Yes.
Can you, at some stage, not now if you've got some other more convenient place in your submissions to do so, can you help me with this? It seems to me probable that at the time when this Constitution was framed, nobody had, even as a little cloud the size of a man's hand, in their mind the thought of virtual sittings, and certainly not the sort of virtual sittings, for example, like today, when you have 5 judges all sitting in different locations, counsel in different locations,
yes,
and even those pressing the electronic buttons in different locations. Are you saying that that the Constitution only permits face-to-face non-virtual hearings, or if not, how do we interpret may sit in the context of a permission given in the regulations for virtual hearings?
Well, you mean for the Court of Appeal? You mean, or
Well, no, I'm thinking of. I mean, you're using may sit. I appreciate it's an expression used in relation to the Court of Appeal, but I think you're saying the Constitution sub silentio in section 80 sub 1 is taken to assume that the Supreme Court may only sit, I'm sorry, in the earlier section about the High Court, about the Supreme Court, section 7, it may only sit in the Turks and Caicos Islands. And my question is how we are to understand that in the context of an apparent permission in the regulations for virtual rather than physical face-to-face hearing.
Well, my Lord, it depends what you mean by a virtual hearing. Yes, I mean,
Regulation 6.5.
Yes. Our bottom line is that that in a criminal trial, the defendant must, if they wish to, be permitted to be present in front of the judge. But of course, the virtual hearing could well cover the situation where witnesses are heard remotely, and we would accept that. It may permit the judge to sit in the court, and if they so wish, counsel to attend part of the hearing remotely. But we do respectfully submit that it's envisaged that there be a court and a courtroom. The judge can, and that's Regulation 4.6, judge can designate some place other than the courtroom in Providenciales as the courtroom, because it's in or outside the islands. But what we say is that so we would have no quarrel under 4.6 with the judge saying, I elect to sit in a hotel or a church, because that's the only place where we'll get enough space to have a jury. I think there has been a case in England where they're holding a criminal trial in a church, and there've been obviously Nightingale courts. There've been use of council chambers where you need to have sufficient space to accommodate a jury and all the council.
I do apologise, Mr. Fitzgerald, but are you saying that on page 542, the Constitution requires the Court of Appeal to physically sit, and that any regulation that permits them to sit remotely is not constitutional? Because that's exactly what the Court of Appeal did in this case, as I understand it.
Yes, yes. Well, my lord, this permits it may sit either in the islands or in such other places, as the President of the Court may from time to time direct. My lord,
you said that that was physically set, and as opposed to anything else.
Yes, yes. It gives it gives permission for them to sit outside the islands. Yes, my lord.
And can that be done remotely?
My lord, you mean that they sit outside the islands in different locations, as in this case?
Yes.
Yes. Well, my lord, can I put it this way? If they do so, it may not offend the fundamental rule of law principles because they're exercising an appellate jurisdiction and not hearing evidence. But
does the word sit then accommodate remote hearings?
What you mean where they're
the purpose of determining hearing and determining appeals, the Court of Appeal may sit. That is either physically or remotely.
My lord, what I would accept is that what I submit is that this envisages sitting physically. There may be some common law power, such as is referred to in Endine, for them not to sit physically, but remotely, but it doesn't derive from the Constitution.
Well, if there is an inherent power in a court to get on with his business, to organize his own affairs, why do we need Regulation 4.6 at all?
Well, my lord, because that's what the prosecution rely on and have relied on throughout. And that's what the application to the judge was made. I have a separate submission that the Endine principle does not extend to a criminal trial, my lord, and that's because it was only developed in the context of a particular type of class action in the civil courts. Sorry.
If I understand the point you've made, that is, the Court of Appeal may have an inherent jurisdiction to control its own process so that it sits in remotely as opposed to physically. Well, why does that not inherent jurisdiction also apply to the Supreme Court?
Well, my lord, the answer to that, in my respectful submission, is where the Supreme Court is conducting a criminal trial, it would be contrary to the rule of law for them to conduct a criminal trial remotely, for the judge to conduct it remotely. So, my lord, that's really the answer. It depends on the nature of the exercise that's being conducted. I say, if it's a criminal trial where liberty is at stake and the judge is, particularly where the judge is the trier of fact, you need to be in the presence or you need to have the opportunity to be in the presence of the tribunal of fact. And so, my lord, sorry, I'm so sorry. Forgive me, my lady.
I just wanted to know where, if the Court of Appeal all sit remotely, they're all in different places, where is the Court of Appeal sitting?
Well, my lady, I say that they're sitting in a place outside the islands if they're sitting.
Which place?
Well, wherever they're connected, wherever I take it it's where the president is sitting. That's where they're actually sitting, and the others are as it were, connecting remotely. But there is authority for them to sit outside the islands, and indeed they avail themselves of that.
Thank you.
I'm so sorry. Well, can I then, because and I appreciate the point put to me by my Lord Stevens, that why are we worrying about Regulation 4.6? But the answer is because that's what the prosecution invited the judge to rely on. That's what the case was formulated as a challenge to, and that is what we say is ultra vires or nonsense. But I will obviously try and deal with the ending point too, because I accept that Justice of Appeals Stolmeyer, I think his ratio was forget Regulation 4.6. On the face of it, it does appear to be a nonsense. But I derive the power from the common law inherent jurisdiction. Could I just show the court then the judgment? First, the judgment of the Justice Lobbin Jackson, which is at page 239 onwards, and really it's just two passages. At page 262 of the e-bundle, paragraph 38, it is against the legislative framework set out above. The court must consider the constitutional validity of Regulation 4.6. Under section 21(1) of the Constitution, if a person alleges that any of his fundamental rights is being or is likely to be contravened in relation to him or her, then without prejudice to any other action with respect to the same matter, which is lawfully available, that person may apply to the Supreme Court for redress. The legislative scheme that applies to the Supreme Court is not the same as that of the Court of Appeal. Clear words of section 80, subsection 2 of the Constitution state that the Court of Appeal may sit either in the islands or in such places outside the islands as the President may from time to time direct. No similar provisions exist in the Constitution in relation to the Supreme Court. The parameters of the court's jurisdiction are then set out in section 3 of the Supreme Court Ordinance. The wording of this section must be given its plain and ordinary meaning when it says that in addition to any jurisdiction previously by it or conferred upon it by this ordinance, shall have within the islands the jurisdiction vested in the High Court of Justice in England. When one looks at section 71 of the Senior Courts Act, it says that the sittings of the High Court may be held at any place in England and Wales. These long-established geographical limitations have been discussed in a number of cases. Then it sets out in Parsons and Canadian Red Cross Society, it refers to, for the same reason that the rigid English common law requirement for enforcing foreign judgments are not suited to modern commercial realities. English common law prohibiting English courts from sitting outside England should not be applied to prohibit the superior courts of this country from sitting outside their home provinces when it would be in the interest of justice to do so. The English common law precluding English courts from sitting outside England is not suited to modern realities of increasingly complex litigation. And then Mr. Mitchell then referred to the Endine case and setting out paragraph 46. As of November 19th, 1858, the English common law did not allow English judges to sit outside their territorial boundaries. The test for determining whether such a law is applicable is based on its suitability, which is to be assessed as at the date of reception. There is no authority from any common law jurisdiction that holds a judge of a court can hold hearings outside his or her territorial boundaries. What limited authority exists is to the contrary. In ending the historical common law restrictions preventing the English court from sitting outside of England was traced back to Magna Carta. However, due to the federal structure of the Canadian Constitution, they did not feel bound to conform to that rule. especially since there is a significant difference between an English court sitting outside of England and a provincial superior court sitting elsewhere in Canada. Because of the legislative scheme outlined above, unlike Canada, the Turks and Caicos Islands are wedded to the restrictions. Can I just indicate to the court what she is referring to there? She's already referred to Part 5, but she also refers to Section 3 of the Supreme Court Ordinance we've dealt with in the case, paragraph 42, at electronic bundle 427, but you have it at volume 2, tab 31, and volume 2, tab 31, page 98. One sees the sittings, this is in England, the sittings of the High Court at 9 to 8 may be held, and any other business the High Court may be conducted at any place in England or Wales. So that's limited to England or Wales. And then that is by Section 3 of the...
I do apologise, Mr. Fitzgerald, for butting in yet again, and bear with me. Does that mean that if an English judge or a Northern Irish judge or a Scottish judge happens to be in France and an emergency crops up, that they cannot then deal with the matter? Would they be sitting in France if they just happened to be in France and were contacted by telephone or by the internet to deal with an emergency application?
Well, my first answer is they can't do it by law, because they've got to sit in England or Wales. My second submission is they certainly can't do it in a criminal case. But my lord, sorry, if I can just give you that A-B answer in that way, that is my submission.
And where is the sovereign power being exercised when they make an order over a telephone and it's received in England? Where is that sovereign power being exercised?
Well, I would accept that the effect of it is if it's a lawful exercise, the effect of it is in England and Wales or in Northern Ireland.
And what's the objection to that occurring? It just move it away from the criminal case. But what's the objection to that?
Well, it's simply the words of the statute that may sit in England and Wales. That it's limited to that. My lord, I mean, you know, we know from Privy Council we've sometimes had to have three-way conversations with members of the Privy Council in their homes, you know, when there's a death penalty case. But so I accept that that does happen. But not that, so far as I know, we've never done it when they've been abroad. They've been in some other part of the country, yes. But my lord, that's what the statute says may sit in England and Wales. But my lord, we certainly say that it's fundamental that should be stuck to when they're sitting in when we're dealing with a criminal case and with the hearing of evidence in the criminal case. Can I just that's the Senior Courts Act in England, and the application of that to the Turks and Caicos Islands is in virtue, it's tab 31, isn't it? Tab 31. I'm so sorry, where's the Turks and Caicos Islands? It's in the ordinance of the ordinance. Yes, Supreme Court, I'm so sorry, it's volume, if I can take the court then to the Supreme Court Ordinance, volume 1, the Supreme Court Ordinance at volume 1, tab 8, you can see that the Supreme Court has at page 614 of the E-bundle, the court shall be a superior court of record, which in addition to any jurisdiction previously exercised by it or conferred upon it by this ordinance or any other law, shall have within the islands the jurisdiction vested in the following courts in England. A, the High Court of Justice. So the High Court of Justice in England may, and we say can only sit in England and Wales, and the same applies to the Turks and Caicos Island Supreme Court. It has the same jurisdiction and exercises it on those same conditions. So that was what the learned judge relied on in saying that there is express statutory provision that you must sit in the Turks and Caicos Islands. And then if we go on from there to...
Just before you do, Mr. Sherrill, I'm looking at section 3.1 on page 614, which is all about the ambit, isn't it, of the jurisdiction of the court.
Yes.
But is there any express incorporation of any sitting requirement condition, or indeed implied incorporation of any sitting requirement condition in section 3.1, or indeed 3.2, which appears not to impose what we might call England and Wales conditions, but any rules made under the ordinance?
Well,
and only to incorporate the practice and procedure of the High Court of Justice in England as far as local conditions permit, and subject to any directions which the court may give.
Yes. Well, my lord, I certainly would have to accept that 3.3 is in the absence of anything to the contrary.
Yeah.
But 3.1, I say that the jurisdiction of the court in England and Wales is dependent on them sitting in England and Wales, and that same implied limit to jurisdiction applies to the Turks and Caicos Supreme Court. In other words, they have a jurisdiction, but it's subject to the condition that they sit in the Turks and Caicos Island. That's my submission. My lords, sorry, my lady and my lords, can I just take you to, unfortunately, there seem to be two sets of paragraph 30 to 40. We've seen the first lot at pages 262 to 264 of the judge's judgment. If we go to page 267, there's a new paragraph 32, and one sees there, whereas the plaintiffs allege that their right to protection of law under section 6 of the Constitution is likely to be infringed by regulation 4.6 on one view, it provides an avenue to secure another right under the same section, that of a fair hearing within a reasonable time. But this does not dilute the requirement by section 20, the regulations passed during periods of public emergency be justifiable in the circumstances. Then it deals with the audio-visual link ordinance, which the board does have in the bundle at tab 3 of the authorities. In that ordinance, court means court having jurisdiction pursuant to any ordinance of the Turks and Caicos Islands. Court point means the courtroom, and remote point means any place other than the courtroom. By virtue of section 4.1 of the ordinance, a court may, having heard representation from the parties in any criminal direct that a witness may give evidence to the court by audio-visual link. However, where the court is constituted in the manner prescribed by regulation 4.6, the remote point becomes the courtroom. The position in the Cayman Islands, I'm not going to deal with that because it's distinguished. If I can go on to paragraph 35, returning to the question of the constitutional validity of regulation 4.6, which states that the courtroom shall include any place, whether in or outside the islands, the judge or magistrate elects to sit. The argument presented by the defendant that the judge sitting outside the jurisdiction would be beamed into the courtroom set up in the Turks and Caicos Islands via electronic means would not suit the wording of regulation. The courtroom is wherever the judge or magistrate elects to sit. And we say that that is a correct interpretation of what regulation 4.6 actually says. And so, my lady and my lords, what we say is, we are strictly speaking correct that Regulation 4.6 is ultra vires in what it purports to do. And then the question is, what can you do in the absence of Regulation 4.6? And then it goes on, given the legislative framework previously outlined, Regulation 4.6 ought not to attempt to alter the existing law where there is no evidence to suggest it was necessary, proportionate to the threat of the pandemic, or urgent to do so, as required by Article 7 of the 2007 order. I think the point she's making is that there was no evidence adduced before the court to justify it. It was just there. And so the issues of whether it was necessary simply wasn't tried out. The regulation makes no mention of any particular territory and is worded in such a way as to be of general application both in the Supreme Court and the Magistrates' Court. So that deals with the in personam point of 37. And then over the page, conclusion. For the reasons given in the foregoing discussion, I declare that Regulation 4.6 is ultra vires the Governor's powers under the Constitution, the Emergency Powers Ordinance, and the 2017 order, only to the extent that it purports to confer powers on the Supreme Court to conduct proceedings outside of its territorial boundaries. I think it must mean from a location outside of its territorial boundaries. And so, insofar as it purports to confer jurisdiction on a judge of the Supreme Court to conduct proceedings from a location outside of its territorial boundaries, we say she's entirely correct to say that it's ultra vires. And if one then goes to the Court of Appeal judgment, can I just take the board to that? It's obviously, we've analysed it in case. Can I just take you to, first of all, for the President, Justice Motley's judgment. At paragraphs 18 to 20, at page 296, the President recites regulation, the judge's declaration, and the judge recites, in arriving at that conclusion at paragraph 18, it would appear that the judge accepted that Regulation 4.6 purported to confer power on the Supreme Court to conduct proceedings must be from outside of the territorial boundaries of the Turks and Caicos Islands. In placing that construction on Regulation 4.6, does not appear that the judge considered placing a purposive construction on Regulation 4.6, nor did she consider applying the mischief rule. In my view, the judge ought to have approached the construction of Regulation 4.6 by placing the plain, I think it must be by replacing the plain meaning rule. If this construction did not provide adequate or proper meaning, she was required to adopt a purposive construction. We say that that is a really sinister process of reasoning. What you say is, if the regulation on its plain wording is ultra vires, the Constitution, then you interpret it in a way which is not unconstitutional by simply looking at a purposive construction. But the purpose there's nothing to indicate that the purpose of the regulation was to provide for judges being beamed in any way. The purpose was to simplify matters by providing, if necessary, for the judge to sit abroad. And the fact that Regulation 4.6 is unworkable is a reason for striking it down, not trying to rescue it by rewriting it. And we respectfully submit that the whole approach of resort to what's called a purposive construction when the words can only mean one thing is simply inappropriate. And if one looks at those words of the statute, of the ordinance, as I respectfully submit, the words can only mean that the courtroom is where the judge or magistrate elects to sit. That's at page 675, to conduct business, and that can be outside of the islands. And that's where the judge, and then the proviso makes that clear, because provided always that the video and audio link facility at the said location. The said location can only be a reference back to the place, whether in or outside of the islands. And so it's attempting to say that the judge can sit there, can make that the courtroom, provided where the judge is sitting is accessible remotely.
Mr. Fitzgerald, just following that thought through, what does include mean then?
Well,
why does the courtroom include, not the courtroom is?
Well, because the courtroom would be for example, the classic courtroom would be the court in Providenciales, which is the court where it normally sits. But the courtroom can include, as I've respectfully suggested, a hotel. Then you could, that can be the courtroom. So it's what, or it could be a church.
Why does it say include? Why doesn't it say is?
Well, because it's not ideal word, because what it's saying is the courtroom can be the place, whether in or outside of the islands, and shall include, just say, it's just supposing it said the courtroom shall include any place such as a hotel, a church, where inside the islands where the judge elects to sit. That makes perfect sense. So in other words, the courtroom includes the courtroom at which you can conduct business can include any place that the judge elects to sit. But what it can't be, because of the words provided always at the video and audio link facility at the said location, that said location can only be the place in or outside of the islands. And that makes perfect sense if you're envisaging inside the islands, that the courtroom could be some place which the judge designates other than the conventional Providenciales courtroom. The problem is that it then tries to do that for some place outside of the islands, and that we respectfully submit is unlawful. But my lady, my lords, what I submit, if Regulation 4.6 means what it says, it's plainly ultra vires, and the attempt to rescue it by rewriting it and getting rid of that at the said location is impermissible. One can't conduct that exercise of saying, well, that would cause problems, so we'll rewrite it. In our respectful submission, that would be doing violence to the primary rule which we've set out in the submissions, that you start with the plain and ordinary meaning, and if it just can't bear such a meaning, it may be that one simply says, well, Regulation 4.6 is too unclear, too confusing, too contradictory to authorize anything, and therefore basically have another go. But it's certainly, this can't authorize, in our respectful submission itself, a change as radical as the judge sitting in a criminal trial in a case such as this outside the jurisdiction and being beamed into it. That has got to be justified by some other source of law, and that indeed was what Justice of Appeal Stolmeyer recognized.
Mr. Fitzgerald, would that be a good moment? We normally have a
Oh, yes.
5-minute break in the middle of the morning because it's quite exhausting for everybody to keep looking at the screens all the time. That be a good moment for 5 minutes?
Yes, my lady. Yes, thank you. Yes.
So we'll just resume in 5 minutes' time, please.
Thank you, my lady. Thank you. Yes.
Thank you very much, Mr. Fitzgerald.
Thank you. Well, my lady, my lords, can I just very briefly show the court that the judgment of the president is at the key ratio is at page 308 of the electronic bundle at paragraph 50. It follows from what I've stated that I do not consider that Regulation 4.6 created any court to sit outside the Turks and Caicos. The regulation, in my view, permits a judge while outside the territorial limits to sit and preside over a trial, which is taking place in a courtroom within the territorial boundaries of the Turks and Caicos. We say that may be what it ought to have said, but it's not what Regulation 4.6 does say, and that is overstraining the use of what's called the purposive construction, but which is just trying to read in words which aren't there. And then it says, then at paragraph 52, for the reasons set out below, I'm of the view that a judge sitting in the circumstances set about would not offend the common law rule. And it deals with the proviso, and it's basically saying, well, it's accessible. Can I just also go to Justice of Appeal Stolmeyer, because we do attach some significance to his first reaction to the plain words of the statute. Page electronic bundle, page 322, paragraph 101. On the face of its wording, Regulation 4.6 is ultra vires. No matter how it is parsed, it is clear that it provides that a courtroom can be a place outside the islands where the judge elects to sit for the purpose of conducting the case. We say that that is the natural and ordinary meaning of the words. Applying the appropriate interpretation rules, however, produces a different result. Well, we respectfully submit, for the reasons that we've set out in our reply in some detail, you cannot misuse the purpose of construction. And you certainly can't use a practice direction published 3 days later to reinterpret the plain words of the regulation. And so the regulation should have been struck down. I should, however, draw attention to the fact that at page 326, he finds an alternative route at paragraph 119. Further, I have also concluded that the common law permits a judge to remain outside the jurisdiction and conducting a trial taking place within it, and deals with the question of Endine, when she restricted her reasoning to the statutory and constitutional federal framework of Canada. It's a common law in the President's practice direction that allows this court to sit as it has to hear this appeal, and that's dealing with the Court of Appeal. Justice of Appeal Adderley is to like effect. Again, he, like the President, draws heavily on the practice direction issued 3 days later, which we say is impermissible. I just draw attention to page 345 of the electronic bundle, paragraph 183. Justice of Appeal Adderley says, a strikingly similar issue arose in the Court of Appeal of Canada in Endine. We say it's not strikingly similar in any way. Firstly, the Endine case involved a multi-jurisdictional class action in a civil proceedings. Secondly, it was absolutely clear that it didn't involve any coercive powers, and certainly didn't involve any criminal trial. And thirdly, they relied on the fact that it was within the sovereign territory of Canada, although in a different province. So the idea that it's strikingly similar is with great respect, a strikingly incorrect statement. And then the the judge upheld it again, adopting the purposive approach that my learned friend invited him. We say that that purposive approach has its limits, as we've set out in the reply. You can inform your reading of the plain words by the purpose or mischief. You cannot rewrite the words, and you have got to make sense of those words in the proviso, which refer to the location. And the location can only mean the location where the person has chosen to sit, which makes perfect sense if the location is a hotel or church in the islands where the judge elects to sit, because then you have that location has got to be accessible by video and by links. It makes perfect sense if it's outside of the islands, because you simply have to have that accessible, but it's unconstitutional. And so we respectfully submit that on the plain wording of Rule 4.6, it is ultra vires and unconstitutional and not authorised by the primary legislation. Those wide permissive language of may make regulations can't authorise a judge to say, well, I'm sitting in Jamaica and it's accessible by video. This location is accessible by video to all those parties, so that's okay. But I do accept that the Endine case was heavily relied on, and therefore I need to deal with that, because as my Lord Stevens has put to me, if there's an inherent jurisdiction, why are we bothering about Regulation 4.6? The answer is because that's the basis on which the prosecution made their request, and they have fiercely defended the intra vires-ness of Regulation 4.6, and they have fiercely said that it is that the declaration given by Lobbin Jackson was wrong, right? Mrs. Justice Lobbin Jackson was wrong. In fact, she was entirely correct to say it's either gibberish, or if it is intra vires, it's plainly unconstitutional. And we say you can make sense of it, but the sense you make of it is plainly unconstitutional. But if we look at the Endine case, can I just deal with that? We say we deal with it in our reply at pages 13 to 14 at 2.22. But can I take the board briefly to Endine, which is in volume 3, tab 44, and there are two judgments. Can I just make these points first of all, which we've set out in our reply at 2.22. It involves an extension of the common law powers, first of all, and the respondent had conceded that there's no power at common law for a judge to sit abroad, but they say you can be beamed in. Secondly, Endine is readily distinguishable because it didn't concern a criminal trial or the exercise of any coercive powers, and that was a crucial point in the Supreme Court when they upheld the existence of the power. It was only on a statutory basis. Significantly, the Court of Appeal's decision was only upheld in the Supreme Court by reference to specific statutory provisions applying to civil class actions. And the conclusion and ratio at paragraph 58 made that clear. And thirdly, there were no provisions of law in Canada equivalent to Section 3 of the Supreme Court Ordinance.
I thought, Mr. Fitzgerald, I thought the Supreme Court upheld, so found that there was, relied upon two statutes for two states, but held inherent jurisdiction on the third one, which was equivalent to the statutory provisions. It's Section 12. There are two Section 12s that gave power to two states to act in this way. But the third one, Ontario, I think, had to rely upon inherent jurisdiction.
Well, my lord, if I'm wrong about that, I apologise. But I'd still make the point that if, well, can I just take you to it? If we look at the Supreme Court ruling, the final conclusion at page 1388, paragraph 58, the judge there, Justice Cromwell, giving the judgment of the majority, says under conclusion, in pan-national class actions proceedings over which the Superior Court has subject matter and personal jurisdiction, a judge of that court has the discretion to hold a hearing outside his or her territory in conjunction with other judges managing related class actions. This is provided that the judge will not have to resort to the court's coercive powers in order to convene or conduct the hearing, and the hearing is not contrary to the law of the place in which it will be held. This discretion must, of course, be exercised in the interest of the administration of justice. In Ontario and British Columbia, this discretion flows from section 12 of those provinces. Respective acts in relation, I see. So it's the inherent jurisdiction he's referring to there. But my lord, look at the very, very close definition of the limits of the extension of the common law. It's in class actions of a civil nature where the Superior Court has subject matter and personal jurisdiction, and only on condition, because it's provided that the judge will not have to resort to the court's coercive powers. So they consider it very carefully, and I can just take you back to paragraph 41 and 42 at page 1383. Are there common law, constitutional, statutory rules that prevent judges from sitting outside the province? The key question, therefore, is whether there are any rules or principles of common constitutional statutory law that prevent a judge from sitting outside his or her province for the purposes in issue here. In my view, there are none. I underline that the power claimed for the Superior Courts in this case is limited. We are concerned here with cases in which the courts have personal and subject matter jurisdiction. There is no claim that the judges sitting outside their home jurisdiction have any authority to use their coercive powers outside their province. There is no suggesting that holding an out-of-province hearing would be contrary to the law of the jurisdiction in which the hearing would be held. Further, this case involves litigation wholly within Canada. So the preconditions are the particular nature of the action, which is a civil case where there's personal and subject matter jurisdiction. There is no, the other proviso to the exercise of this power, and it's a proviso therefore limiting the power, is that there's no resort to coercive powers, which obviously wouldn't apply to a criminal trial. And then finally, the case involves litigation wholly within Canada. One of the points was that it was just from one province to another, not from not exercising a power outside Canada in respect of Canada. We've cited the various passages, but we do, yes, and at paragraph 27.
Mr. Fitzgerald, before you move on from this, arising out of my Lord Stephen's question, in his judgment, Justice Cromwell, at paragraph 59 and following, goes on to deal in detail with the question of inherent jurisdiction.
Yes.
And appears to conclude at the end of paragraph 62 that there is a basis in the inherent jurisdiction quite independent of section 12.
Yes. 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 But it is limited in our respectful submission to the principles at 58.
The difficulty I have there, Mr. Fitzgerald, is what are the coercive powers that are being exercised by the judge in Jamaica? all the coercive powers are being exercised in the islands.
Well, sitting in Jamaica, well, can I just put this position? Supposing there is a contempt of court issue arising, or a compelling of a witness to attend, both of which involve coercive powers, he would be exercising that from Jamaica. Sorry, I'm so sorry. My Lord Briggs.
Yeah. Provided Lord Jones has finished his question.
Yeah.
Yes, thank you.
So sorry.
But suppose that the witnesses were giving evidence in a courtroom or a building or a hotel in the Turks and Caicos, and the judge ordered that there be a subpoena to give evidence in that hotel room in the Turks and Caicos, but he made his order while sitting in his living room in Jamaica. Would he really be exercising his coercive power in Jamaica? It might be said against you, he's actually exercising his coercive power in the Turks and Caicos.
But he would be exercising it from Jamaica, and that's
yes. But
yes.
Isn't the, I mean, coming back to Endine, isn't the concept of the exercise of coercive powers more to do with where that power would be exercised than from where the notification by the judge of his exercise of it was taking place, bearing in mind principles of comity, which one wouldn't expect a judge of country A to order something to be done in country B while he was sitting in country B.
Well, except, my lord, that in the Endine case, the judge was outside the jurisdiction, and he was, and it was only because he wouldn't be exercising coercive powers that it was okay for the judge, though outside the jurisdiction, to exercise those powers in respect of another jurisdiction, to give judgment that was binding on another jurisdiction. In other words, one has to. Why is it that they say there's no question of any coercive powers being exercised? It's because, in our respectful submission, it's because there's no question of any of the judge in jurisdiction A exercising the coercive power in respect of B.
Yes.
I mean, he's got to be in the place where he's subpoenaing or committing for contempt. He can't do it remotely, is what we invite the board to derive from the Endine judgment. Well, my lord, I see I haven't persuaded my Lord Briggs.
Well, I don't know. No. The fact I furrow my brow, Mr. Fitzgerald, merely means I'm thinking about it.
Oh, well, good. Okay.
Mr. Fitzgerald, isn't the problem which is addressed here the concern that enforcement jurisdiction should not be exercised in another state?
Yes.
It's Canada, so we're talking about different provinces within the same federal state. But one can see that if you transpose it to different states, different jurisdictions, that there is understandably a concern that there shouldn't be a breach of international law by seeking to exercise enforcement jurisdiction in the territory of another state. But if a judge who happens to be abroad for the weekend signs an order which he sends back to England, which is going to be enforced there for a witness to attend, there's no risk of that, is there?
No, there's no risk, but it still offends the principle that when you're conducting a criminal trial or exercising coercive powers, you should be within the jurisdiction where you're exercising those powers. That's our respectful submission. But what we do say is if one looks at the Endine judgment in the Supreme Court, it does seek to restrict to a very narrow situation the power that it finds exists in the inherent jurisdiction, and it's only confined to that particular case. And they expressly make the point that if it were to be any wider power, it would have to be in legislation. It wouldn't be for them to innovate. I think that's and there's the reference to at paragraph 45 I accept that there is a deep-seated sense in the common law that courts conduct their business within their geographical boundaries. And then one deals with that deep-seated sense at paragraphs 46 and onwards. So that's why it says at paragraph 49 that it's not this, what is proposed here is not the sort of major procedural innovation that ought to be left to the legislature. On the contrary, the legislatures have, through section 12 of the Acts, encouraged courts to make full use of the powers to regulate the process. Allowing courts to hold the type of hearing in issue here furthers the legislative intention evident in the scheme. Far from usurping legislative authority, this approach uses the authority broadly conferred by the legislature to further its objective. So there was, as it were, already a legislative steer that was okay, that justified not leaving it to the legislature. There's no such parallel argument here that there's a legislative steer that criminal trials can be conducted by a judge sitting in another jurisdiction. Far from it. My lady and my lords, I do have to deal briefly with the inequality of arms, and I'm sorry if I've taken too long on the first point, but I'd simply make this point. In relation, we deal with this in the case in the case, ground 3 is paragraph 77 onwards, and the board has that at page 442. And what we respectfully submit is two things. Firstly, this undermines effective participation because this is second best. The judge hearing the defense witnesses as opposed to the prosecution witnesses remotely. And we've set out from paragraph 79 onwards the materials to suggest that this would be a shift, and this is what we submit at paragraph 79, would be a wholesale and radical shift halfway through the trial and applying only to the defense cases in the way in which evidence is given. And such a marked change would place the defense at a substantial disadvantage. Now, we've set out then the findings at paragraph 80 of the Equality and Human Rights Commission report, referring to the fact that they heard evidence which you have at tab 61 from 2246 onwards, that the human element may be missing when you're hearing it remotely, and both people and behaviours can be easily misunderstood over remote technology. You're less well able to represent yourself. We've also put in the reply the judge's statement that, can I just give you the reference, in pages 17 to 18 of the reply, the remarks of Justice Snedden about his own experience being that remote technology is less positive. The available technology cannot fully replicate the courtroom environment, which is so often central to an adversarial system, and that's of civil judgment. And he says, in my experience, the technology inhibits the cadence and chemistry that personify well-run cases. And those are traditional forensic benefits of which litigants ought not too lightly to be deprived. So we do pray and aid what Justice Snedden says in the Rooney and AGL Energy case. We rely on the Equality and Human Rights Commission report, which we've cited at paragraph 80 of the case. We rely on the report by Transform Justice, which we've cited at paragraph 81. and that can be found at volume 6, tab 71. And they made the findings. Defendants who appeared on video from police stations were more likely to get prison sentences and less likely to get community sentences. And they interviewed criminal justice professionals in connection with that report who expressed concerns about technical and practical issues which could have the effect of making participants feeling disconnected or remote from one another. And finally, at paragraph 82, we've referred to the Justice, so this is at page 445 of the bundle, we've referred to the Justice Select Committee of the UK Parliament recommending that Ministry of Justice should commission independent research on video hearings and video links with a primary focus on justice outcomes. And that's, so we rely on that. And so what we submit at paragraph 83 is that under the 2003 Act as amended by the Coronavirus Act, you do not have, I think we may be wrong about the defendant not being able to give remote evidence, but certainly jury trials are excluded from being held remotely, and that's in the additional bundle, if you have the additional bundle, where we have the provisions at page 26 of the 2003 Act as amended, live links in criminal proceedings. 51.1, a person may, if the court so directs, take part in eligible criminal proceedings through a live link or live audio link or a live video link. And then it says a direction under this section may be given for a judge or justice to take part in imminent criminal proceedings for a live and audio link. But in this part, eligible proceedings means a summary trial, not so jury trials are excluded. But if you then look at the position for a summary trial, which is dealt with at page 31 of the additional bundle, the basic position, and 32, that it's at subparagraph 8 of, it's 2 subparagraph 8, condition G, a summary trial in a magistrate's court, you can have a direction for remote hearing, but only if the parties agree to the proceedings being conducted wholly as video proceedings. So essentially, where the trial is a first instance trial of criminal guilt, it cannot be imposed that there be remote hearings. And we do respectfully submit that that gives some indication of the importance of actually being present before the decision maker, whether it be the jury or the judge in a judge-only trial, and experiencing, as the tribunal of fact experiences, the evidence being given. And then the final point we make, which is from paragraph 86 onwards in the case, is that the application of regulation 4.6 so as to give effect to the respondent's proposal would create such a marked difference in presentation of the prosecution and defence cases that an appearance of imbalance cannot but be avoided. And in those circumstances, especially given that the judge must adjudicate the facts in this case, to continue as planned would entail a violation of the appellant's right to a fair trial. I accept, my lady, that the judge has not yet made a decision, but for the judge to be able to do that, we say, would result in a marked imbalance. And every indication, as I understand it, is that if if the court rules that the judge has the power to conduct proceedings from Jamaica by being, I quote, beamed into, that there is every possibility that he will avail himself of that. And though we've abandoned the in personam challenge, it's clear that the regulations had this case at least in mind when they provided for the judge sitting in Jamaica. So, my lady, that's the point that we make in relation to the inequality of arms. If I can take you next, just very briefly, in what remains to the reply, if I can take you to our reply at part 3, as my lady observed, that's where we set out our objection. And at 3.4, we make the point, appellants did not and do not object to the limited and appropriate use of technology within the context of their criminal trial. For example, where it's case management or simply a legal ruling. But the appellants have never accepted and do not now accept, at any rate, that it is open to the judge to hear evidence in their trial in circumstances which deprive the defendants and their counsel of the opportunity to be in the physical presence of the judge whilst he hears that evidence. And we say that such a scenario runs counter to Part 5 of the Constitution. It would equally, our objection would apply if he sat in a private residence within the islands to which there would be no opportunity to attend in the physical presence of the judge. So, my lady and my lords, various examples have been put to me about signing some order from France in an English case, or just some formal step being taken and saying, well, why can't that be done? This is radically different what is proposed. What is proposed is that the judge should be able to conduct the whole trial, if necessary, from now on, from Jamaica, being beamed into the court in the Turks and Caicos. And we say that that would of itself, that possibility would of itself violate the principle of equality of arms, because you've had the first part of the trial with the prosecution witnesses giving evidence in the presence of the judge and with the defendants present. Now the proposal is that the defendants themselves, if they give evidence and one of them is still giving evidence, and any witnesses that they call, will be heard by the judge sitting in Jamaica. We say that that possible scenario runs completely contrary to the principle of equality of arms and would deprive them of the important safeguard of being present in the physical courtroom with the judge when he hears the evidence. And so we make the point that it's important, we say it's important as part of the concept of the protection of the law and due process, that where the evidence is given by the witness in court, the defendants should at least have the right to be present and see how the judge reacts at the time. And that's really about issues of demeanor, which we say, whatever my learned friend says in relation to there being research to show that judges don't rely on demeanor. There's also a long-standing principle that demeanor is an important part of assessing, but it's also that should be assessed by the defendants and the judge in the same physical space. We say that that is an essential safeguard, and in any event, to switch into a different type of hearing halfway through would offend against the principle of equality of arms. So we've set that out again in the reply. Firstly, on 4.2, video is second best. We've set out the principle that it's second best, relying on what was stated by Justice Snedden at pages set out at 4.3. His point about the technology inhibiting the cadence and chemistry that personify well-run cases. And then the second point we make is the broader one set out at 4.5 of the reply, that it means that the defence would have a reasonable sense that there was an inequality and imbalance and a real appearance of unfairness, that if the judge could switch to a hearing which is a remote hearing of the witnesses at this stage. And at 4.6, we make the point that Justice Lee, in the case of Get Swift, observed no litigant, particularly a litigant involved in serious proceedings, should apprehend that they will be materially prejudiced by reason of the mode by which a trial will be conducted. And we've also cited the many family cases dealing with the problems of being deprived of an in-person hearing. We submit that the court must be satisfied that both parties are placed on an equal footing in respect of the matter before it, and that's the citation at page 20 at 4.6, and to have the prosecution evidence all heard by the judge in his presence, and then to permit at this stage for a hearing in the absence with the judge beaming in remotely from Jamaica would give rise to an appearance of unfairness and would deprive the defendants of a time-honoured safeguard that they're present with the judge, hearing the evidence with him, having the same experience as him, and being able to refer to the same points as the judge. So that's why we respectfully submit that in any event, this contemplation of the judge sitting abroad, presiding over a hearing in the Turks and Caicos, it would in this case violate the equality of arms principle and the protection of the law principle because of the substantive handicaps it would cause the defendants and the genuine sense of an appearance of unfairness by, as it were, changing the nature of the hearing halfway through. My lady, those are the points that we make in relation to the inequality of arms, and I know the court has our submissions in relation to the first point. So basically we say you can't rewrite Regulation 4.6. It plainly means what it says, and it has a discernible meaning, but it's a meaning which is ultra vires the Constitution. And secondly, having regard to the Endine principle, we say that the Supreme Court, for very good reasons, said thus far and no further in the Endine case, and this would be going a very great deal further without proper legislative authority. Those are my submissions.
Thank you very much indeed, Mr. Fitzgerald. I'll just look to see if anybody wants to ask you any urgent questions. No. Thank you very much indeed. Mr. Mitchell.
I'm grateful. Thank you, Lady, my lords. From early morning here in Turks and Caicos, it's now 7:30 in the morning. We are in a worldwide pandemic, and it's important to contextualize this. This is, and to the extent that I need to focus on the trial, because my learned friend has, this is a trial that has lasted a very long time with a judge who has elected, for very good reasons, to live in Jamaica and commute to the trial. He adjourned as the worldwide pandemic was declared. He didn't adjourn in April, as my learned friend had said. He adjourned to April, and it was in April that he then again adjourned till June. And then, of course, by then, this constitutional motion had been taken, and he has remained stoically silent as to when we will recommence. Though clearly one can infer from his age, from the stay-at-home or stay-in-place recommendations of all the medical authorities, wherever you may look, that his preference would be to continue the trial so far as it is exceptional and necessary from his home until such time as it is safe to travel. Your ladyship asked at the beginning whether things have changed. The background is that there were very few cases to begin with. There were then many hundreds. It has slowed down to almost nothing over the last few days, perhaps even few weeks. Since the end of July, the borders have been open, but there are preconditions. You need to have a COVID negative test at least 5 days before you travel, and you need to have health insurance. Health insurance because the medical facilities here, whilst perhaps sufficient to cope with a minor outbreak of serious cases among the resident population of around 35,000, certainly couldn't cope if many tourists became unwell. So the background is that, in addition to the necessary statement that justice needs to carry on, but it needs to carry on in a safe and healthy environment. Just as a matter of fact, the Crown had, and hopefully the court will accept this from me, begun the process of inviting the judge to sit remotely before Regulation 4.6 appeared, 48 hours or so before we submitted our document. We had already constructed an argument that the judge should be able to sit, if he wished to, remotely from his place. And so that raises the important issue in relation to Regulation 4.6, which is where I begin. And that is what was behind the regulation and the intention of the governor and the House of Assembly. It certainly wasn't to create a new jurisdiction, we would submit. It was to enable justice and the wheels of justice to continue to turn, albeit perhaps in a less or perhaps slower way than had been occurring before, in the sense that everything was going to have to be done as much as it could be remotely. Importantly in that context, your ladyship and my lord will note, and I will come back to this, that in Scotland, the jury are in cinemas. The court sits where the court sits, but the jury are sitting in cinemas. And the point that I make about that is, and of course I have to come back to it, is my learned friend's submission that it's important that the defendants feel a sense of presence with the trier of fact, where trials are taking place with the jury in the cinema, the court is assembled, and the defendants and the rest of the court see the jury on a video wall as the jury see the court on the cinema screen. So that if you were to come to the conclusion, and we submit that this is not, as part of these introductory remarks, a constitutional issue, but it was constitutionally unfair for a judge not to be in the presence of the defendants. That may present us with some wider difficulties, not only in Scotland, but also under Section 51 of the Criminal Justice Act, as amended by the Coronavirus Act in England and Wales, because although my learned friend is right that jury trials cannot take place as a whole, an emphasis that I make that he didn't, by video link, there is certainly provision for trial on indictment to take place by video link. So rather ironically, it is anticipated within the English and Welsh legislation that there will be trials on indictment that in part will take place by video link. And in addition to that, and I'll come back to it, there is provision within Section 51 for the judge to sit remotely. And so we end up in a position where learned friend's generalized constitutional challenge is not only a challenge, but he says, based on fairness and access to justice, but one that challenges the attempts that are being made, and I've given but two examples in the United Kingdom, to overcome the problem of access to justice in the context of a pandemic. No one is suggesting that this position, so far as Justice Harrison is concerned, or any other judge, it is to be seen as anything other than a temporary measure, whilst restrictions are in place, whilst the issues of health of the nation, the health and safety of court officials, the health and safety of the defendants and counsel remain of concern. And I am sure that your ladyship and my lords would be content to assume that a judge, taking Justice Harrison as an example, with the experience and standing that he has, would see it appropriate to return when it is right to do so. So against that backdrop, let me turn, if I may, to the two main issues of the appeal, now that ad hominem has been abandoned. However, although it has been abandoned, I do remind the board that, of course, the main plank of our answer to the ad hominem appeal was discretion. And it's plain that the appellants recognise that the discretion vested in the judge to decide whether or not to do something really does make it very difficult to run, or impossible, to run the ad hominem argument. And so if one takes the ad hominem argument out, but leaves on the table the issue of discretion, we then turn to look, please, to the two main issues in the appeal. Is Regulation 4.6 unconstitutional? Because in permitting a judge to link to the court in the Turks and Caicos Islands to exercise his or her jurisdiction and authority, it has the effect of undermining the Constitution as to the place of sitting of the Supreme Court. And as a subset to that, is it in conflict with the Supreme Court ordinance to be read in light of the Senior Courts Act of England and Wales? And the second main issue is, if the regulation is itself compliant as to jurisdiction, or if I may put it another way, if there is jurisdiction, whether within or without the territory, for a judge to be remotely linked to the court, should it be struck down, that is, held to be constitutionally unfair, to allow a judge to determine where he is in a part-heard case, to continue the trial until such time as it becomes otherwise safe to travel in his mind. And I want to add the in his mind because one can see the other side of this argument looming down the road, and that is we didn't have a fair trial because the judge was forced, given his age and health, to come back to the Turks and Caicos Islands and must have been constantly thinking about himself, his health, because it would personally be a priority for him. I don't know whether my lady and my lords have made personal decisions to remain at home and not go into, if I may call it this, the office. But it's plain that it will have featured as a part of the process of determining where one is, considering one's own personal position. And I suspect, without doing any more than making the observation, that my lady and my lords are feeling for health and well-being issues better in place than commuting to the Supreme Court building in Westminster. In the same way, the judge, who was appointed living in Jamaica, as was understood, has established a well-trodden path of sitting for 3 weeks, having a week off, and then going home for a week and coming back. And then, obviously, interspersed with the necessary Easter vacation, Christmas vacation, summer vacation, and what has become known as the hurricane break, when we had a little break during September, October, for fear that we might all get washed away. And indeed, one summer, that was quite a good call because we nearly were all washed away. But the fact of the matter is that he has come into a routine. In order to avoid the risk of any changes to travel arrangements, either from Jamaica or from the Turks and Caicos Islands, of course, it may be the judge will, whilst this pandemic still survives, be forced into making a decision if he's told to come here, to stay here. And again, you can see that as being ground to be in any appeal about the fairness of the trial process. And so when I sit with respect to compare that with the second best principle that learned friend Mr. Fitzgerald referred to in respect of the judge seeing and watching the witnesses on a screen, you'll no doubt understand that my respectful submission would be that that is preferable to a suggestion that the judge is under stress or in some way personally inconvenienced by having to deal with the issues of the pandemic personally and directly. That all, of course, goes to the issues of equality of arms. It doesn't strike to the issue of Regulation 4.6, which is where I must begin the main part of our submissions. You will have seen that we deal with learned friend's case on Regulation 4.6 between well, I'm just going to use the electronic bundle references. I myself will get very confused if I start using tabs and other pages. I'm just going to give you the electronic bundle references. It's our written case, electronic bundle 454 to 465. And so the question is, the real challenge, that Regulation 4.6 as read cannot mean what it is that 3 judges of the Court of Appeal have concluded that it does mean, even when one of them started from the position of agreeing with the learned friend. They have come to that conclusion without me rehearsing in detail each of the paragraphs, though some I will necessarily have to come to, they have reached the position, it would appear, in the following way. One, the court can't sit in Jamaica. And I'm going to personalize it, but I shouldn't, because I'm conscious that it's not just Mr. Justice Harrison who is impacted by this decision that is under challenge, but all the judges. And I say that, we've referred to it in our case, but you will have picked up that none of the judges are residents. They all have their homes in other countries. I don't know whether this country is unique. I suspect it's not, because one only has to reflect on the Eastern Caribbean court, where the judges are appointed to islands but are itinerant, in the sense that they are not residents in that particular country. They go to sit in a country, they can go and be moved around by the Chief Justice. And so there is nothing to say. And indeed, in respect of one of the judges, Mr. Justice Aziz, caught for 3 months in the United Kingdom, and because of the decision of Mrs. Justice Loban Jackson, was not able to conduct any work as he may have otherwise wished to do so. So this is of general application. I'm not trying to argue the ad hominem point, but I am making the point of general application, that it is not just Mr. Justice Harrison who's affected, it is all of them potentially, number one. Number two, the issue in relation to 4-6 was plainly an intention to try and create a regulatory framework that would reflect what the common law is. It wasn't, and we would respectfully submit, can't be read as meaning that the governor and the House of Assembly were seeking to create effectively a court in another country. And when you are allowing for legislative drafting and its exactness, you have to apply not only the purpose test and the mischief rule, but you also have to look at it as we submit appropriately so, the context. Regulations written in a time of emergency in order to achieve what purpose? Certainly not to create a court in another country, but certainly to take into account and consider the different issues relating to the judiciary and the need to allow the wheels of justice to continue, and therefore to seek to set about a scheme that allowed the judge to complete the jurisdictional jigsaw of the Supreme Court in the Turks and Caicos Islands by joining remotely from wherever he or she may have been. And that's what we respectfully submit lies behind the regulations. I can't and don't disagree with the observations of Mr. Justice Stolmeyer at the beginning of his judgment, but strictly on its face, it doesn't work. But you have to take into account the fact that we are in a small jurisdiction that is trying to regulate itself in a way that enables justice to continue. And what plainly the drafter of the regulation was seeking to achieve was to continue justice not anywhere else other than in the Turks and Caicos Islands. And so when the learned friend says he can't sit in Jamaica, of course he can't sit in Jamaica, because sitting in Jamaica means that he is applying, dealing with, resolving issues in Jamaica. Indeed, as I said, I think to Mrs. Justice Loban Jackson, he is now that he's retired in Jamaica, possibly still the Honourable, but certainly simply Mr. Paul Harrison. He only becomes Mr. Justice Harrison when he is connected to the authority and jurisdiction in the Turks and Caicos Islands. And that is what we respectfully submit lies behind Regulation 4.6. And if that is what lies behind Regulation 4.6, then all the judges were right in the Court of Appeal to say, A, you've got to give it a purposive interpretation, and that purpose was to create or complete the jurisdictional jigsaw of the Supreme Court. And you have to consider what the mischief of the drafter was, and that was to aid the discretionary jurisdiction of a judge to determine where and how he or she may continue or undertake proceedings in the Turks and Caicos Islands. So putting it another way round, and then adopting, if I may, and I'll turn to it, Justice of Appeal Adler's an analysis at paragraph, it's on page 330, but I just want to get there by making this submission. The judge, wherever he may be, whether in that hotel room or that church to which Mr. Fitzgerald has referred, in his home or elsewhere, wherever he may be, is not holding court in the hotel room. He is not holding court in the church. Your ladyship, my lords, are not holding court in your studies, wherever you may be. You are the board of the Privy Council, together holding court in the Privy Council. And so when a judge decides to hold court under the provisions, we submit it's in the Turks and Caicos Islands, because he can only do it if he is linked to the court recorder. He can only do it if the parties and counsel and witnesses are all able to see and interact. And so if we pick it up, please, at electronic bundle 330. The short question, paragraph 132, was whether Parliament intended to breach the common law rule that a judge of the Supreme Court does not have jurisdiction to sit and adjudicate cases from outside the geographical boundaries of his court, not having been expressly empowered by the Constitution, as are the Court of Appeal. Something I might have to come back to. The whole case, as it was submitted in the opening of the appeal, boils down to whether the physical place of the judge is determinative of his jurisdiction and authority is being exercised, or whether the place where the judge elects to be located outside the jurisdiction islands is beamed into by a regulated court, administered and organized video and audio link, accessible to the court recorder and the public, is the place where the jurisdiction and authority is being exercised, so that by way of audio-visual technology, he is virtually present and sitting, in inverted commas, in the Turks and Caicos Islands conducting the hearing. The respondents submit that if the judge is physically outside, that's where his authority and jurisdiction is being exercised. On any analysis, that can't be right, because he only becomes Mr. Justice Harrison when the link is turned on, when he has the authority of the court and the jurisdiction, therefore, to exercise the coercive powers of the court. One example has been, the learned friend used it, and I'm going, if I may, to return it to him over the net. It is the contempt. If a witness, and indeed it was an example used by Mr. Misick, Queen's Counsel, in the course of the hearing at first instance, if one of the witnesses is in contempt, refuses to answer a question, or refuses to come to court, the judge isn't going to go out and personally arrest him, therefore needing to be in the jurisdiction. But if the video is on and it's being recorded, and the court has a record of the judge making an order that witness B be arrested, brought to court, is there really an answer that says, oh, well, the judge made his pronouncement from Jamaica, and therefore we can't go and exercise this warrant? Or is it that the court has a warrant, has a record of the warrant, has the judge exercising his authority in his place, and goes out to arrest the witness? And we submit, of course, it's the latter, not the former. And if we work through, therefore, the rest of Mr. Justice of Appeal Adley's judgment, we can see that he refers to the Court of Appeal's jurisdiction to sit inside and outside the islands. And I make this observation: yes, they were able to sit, are able to sit outside the islands, but that is not the basis upon which the Court of Appeal heard our case, or heard any of the cases during their long 3-4 week sitting a couple of months ago. They exercised their authority. If you turn, please, to electronic bundle page 717, according to the practice direction which they made, and if you allow me just a moment, I've got everything on my iPad, so I just want to bring up the right page. Your Ladyship, my lords, will see the Court of Appeal of Turks and Caicos Islands Practice Direction 1 of 20. And you will see this, and this, we submit, is effectively what Regulation 4.6 is seeking to achieve. The President and Justices of Appeal will appear and preside together in the courtroom where the Court of Appeal will be convened on Providenciales, Turks and Caicos Islands, remotely by video links from the locations of the President and Justices of Appeal in Barbados, the Commonwealth of the Bahamas, and the Republic of Trinidad and Tobago. And that, we submit, is how you should approach the issue of interpretation of Regulation 4.6. The purpose of it was to bring everybody together in the courtroom in the Turks and Caicos Islands, wherever they may be, and in particular, of course, in the circumstances that we are looking at, the judge. And that's where we submit the court has its seat, and that is therefore where we submit the court would be sitting. Its seat is where its authority and jurisdiction resides, not where you happen to be. And we submit, as we have sought to argue in our written case, that when you look at an analysis of what sitting means, first of all, there isn't any hard and fast rule about it. But secondly, and importantly, the way that it is to be interpreted is where the court exercises its jurisdiction and its authority, and it can only exercise its jurisdiction and its authority in the place where it has that jurisdiction and authority. And Regulation 4.6 was not designed to exclude that way of working. It wasn't designed to create a new jurisdiction, which, taken to its logical conclusion, would result, we suggest, in learned friend contending for the parties going to Jamaica. Not that he would want this, because it couldn't happen, but that must be his interpretation of the jurisdictional provisions within Regulation 4.6, because that would mean if we all turned up in Jamaica, we could carry on. We can't, and we couldn't, because the Constitution doesn't provide for it, and indeed that would breach the sovereignty provisions and all of those issues. But it's either, it means one thing or the other. And it certainly doesn't mean that we can all go to Jamaica. I think it must be 1 o'clock.
Yes, it is. Thank you. Very good timing. Thank you very much indeed. We will start again at 2 o'clock. Thank you.
Thank you, lady.